PIL number.
Parenting issue.
Oh, I see.
Yes, my lord. In that matter, the first writ petition I appeared, my lord, so many times.
Our name was not recorded.
Case number 2.
Lord, I am for the respondent number 1.
Stay down. And my lord, suit also be disposed of, lordship.
I am appearing on behalf of the appellant, my lord. Against the dismissal of the claim case, I have come before your lordship. There is a delay of, my lord, paper book has been prepared, my lord. There is a delay of 20 days in preparing the appeal, my lord. Dismissed on the ground, yes. Dismissed wholly on the ground of identity of the victim, my lord. The victim himself, my lord, appeared.
Lok Adalat failed.
My lord,
You are appearing.
I'm appearing.
Sent to Lok Adalat failed.
And
Lok Adalat. No, my lord, it can be disposed of here and now.
Here and now.
my lord, actually, on the ground of identity, my lord, claim case has been dismissed. Though, my lord, claimant has appeared before the,
So we allow the appeal.
my lord.
Formal objection maybe.
We'll record your gracious presence. Give us
My lord, serial number 4, I am for the appellant, my lord. This is also this,
The insurance company.
my lord, there is a delay.
How many days?
My lord, it's a death case dismissed by the learned commissioner, second employees compensation commissioner. My lord, there is a delay 1,379 days. My lord, kindly condone the delay, my lord,
What is the reason?
considering
100, 1,000.
1,000.
How many days?
1,379 days.
More than 3 years.
My lord, what happened, my lord? My lord, kindly see the my
Have you
section.
served? You have been served.
Yes, my lord.
Yeah, sir.
Oh. Claimant.
My lord, after my lord, kindly see my lord paragraph number 4, my claim can application, my lord.
Why so much delay?
My lord, after passing the award, who was conducted the advocate before the learned tribunal, the appellant was instructed to apply the certified copy with immediate effect, and the learned advocate applied the said certified copy. But after receiving from the certified copy from the concerned department, the learned advocate was fallen ill, and due and
No, you have not been able to establish, unlike the previous case, that your husband was under the employment of Pavel Mullik. Now, Pavel Mullik was
Pavel
not-
Mullik.
So Pavel Mullik was not examined.
Pavel Mullik was a deceased. Pavel Mullik, the deceased employee. Bina Mullik was the applicant. Bina Mullik was the widow of the deceased.
So Pavel Mullik was under the employment of someone who is the owner of
M
the
for
plant.
construction.
So they were not called for any. You have not called them for establishing.
No, they did not appear before. They did not examine before the learned commissioner, but they appeared and filed written statement and admitted the employment. Paper. My lord, kindly see the page number 3 of paper book. Just it is the written statement filed by the employer, M for construction.
Page number.
Page number 3, my lord. Page number 3 of the written statement. Paragraph number 3. My lord, accident is admitted and employment also proved. And here is 2 witnesses have been examined before the learned commissioner. My lord, kindly come page number 17 of my paper book.
কোনো পেপার নেই, কোনো পেপার দেখায়নি, বুঝছিস তো?
লোকে যদি deny না করে, so who filed the written statement?
OP number 1.
And he has stated that.
The deceased was his
Where?
paragraph number 3.
Paragraph page number.
Page number 3. Paper book. Page number 3 of the paper book. Without prejudice to the right and consent of this opposite party admits that the victim Pavel Mullik.
And whether it was denied during evidence.
Yes.
My lord, the M4 construction did not come and depose before the learned commissioner. The co-employee has come. My lord, kindly see the sketch map. The sketch map, page number 23. Page number 23 of the paper book.
There's a disturbance in the evidence. The applicant has produced death certificate and other documents. There's exhibit 2 series.
My lord, I have filed.
Just a minute. Wherefrom it appears that Pavel Mullik was admitted on 8th February 2006 with injury. The death certificate shows the date of death is 2nd February, whereas the case of the applicant is that on 8th June he died. There's a discrepancy. What is wrong
My,
with that?
my lord, I filed CAN application wherein
My lord, I can say this was a mistake
Yes.
because the real death certificate has been corrected and they have given it.
yes,
my
my
lord.
lord. We filed also Water 41 Rule 27 petition.
Because the injury report and the page
Then
20.
then we should allow it.
Yes,
Straight
yes, OP
Straight up,
number
straight up.
2, PW2.
Straight
Yes,
up.
my lord. PW2
So,
Urup
thank you for
Mojumdar
your fair
co-employee.
submission.
Co-employee also came and admitted the employment.
Yes, yes.
Claim number 5.
5, my lord, I made a mistake in mentioning, my lord. This is my appeal was FMET 22 of 2024, and I mentioned 2025. My lord, this is Mrs. Paul's
And my lord, in that
appeal.
case, my lord, I am appearing under the owner of the vehicle.
Sorry,
Well, I am
it has
for
come
the-
before us.
This may be sent to court number 30.
Single
They did MB.
It has come
No,
before
no,
us.
no. This is from Workman.
Oh, acha. I mentioned it wrong, my lord, by mistake.
Mrs. Paul,
This will go to the other bench.
No,
Go
no.
to the other bench. No,
that will come. Kindly take it after vacation.
after vacation.
My lord, I am appearing
And
for
my
the
lord,
opposite
my-
party. I am asking them to serve me a copy of the
So
application.
what is this matter? Please tell us.
It's under workman compensation. I mean, opposite party.
Now, why you said you have mentioned by mistake? I can't follow.
My lord, 22, 2024, I should have mentioned, I mistakenly. My lord, that
This
way.
this matter is different matter.
My lord, my
Different.
So matter different matter. Appearing by mistake kore do, appearing wrongly appearing.
And I am for the appellant, my lord. The point, my lord, which will fall for consideration before your lordship is interpretation of section 147 and 149 of, my lord, the principles of Mohammedan law. Now, my lord, what happened? My client, my lord, filed, my lord, a suit for declaration of title, which was ex parte dismissed. Challenging that an appeal was preferred, my lord, that is also, my lord, dismissed. Challenging that, I am before your lordship. Now, my lord, the point is, my lord, whether oral gift, my lord, heba is permissible and whether the conditions of oral heba has been fulfilled here. Effect আছে? Effect আছে?
The oral heba is under the Mohammedan law. Oral gift is permissible.
Yes, yes.
So
Court,
it does not require any registration.
exactly. And court, my lord, if your lordship kindly see, my lord, page 6 of the appeal court's order, court has said, my lord, all ingredients, my lord, court says, my lord, 123 of the transfer of property concept will not apply here. Still, my lord, dismisses my suit and appeal. Kindly see page 6.
But there are some conditions.
That is also recorded, fulfilled. Attesting witnesses, my lord, came and, my lord, subsequently that oral heba was reduced in writing. Attesting witnesses deposed and said, yes, possession was handed over.
But subsequently they produced one.
That was reduced in writing. Initially, oral heba was reduced in writing. Now, my lord, the attesting witnesses, they have come and proved that, my lord, the only thing which is required to be proved is possession. They have
Acted upon. Gift has to be acted
upon and possession. Kindly see page 6
So,
of the appeal
so-
court's order. Court has recorded all ingredients have been fulfilled, still dismisses my appeal and also consequently the suit.
Now, how this oral heba differs from the recitals in the unregistered deed of gift?
No, kindly see, my lord, page 6 of the appeal court's
So
order.
please tell us how
Yes.
that.
Oral, there is no difference. There is no difference. Oral heba is oral. I have to prove by way of, my lord, evidence. Kindly see, my lord, this paragraph, second last, on perusal of the
No.
oral heba.
You claimed first on oral heba, second by way of adverse possession.
No,
Yes.
it was reduced in writing.
The plaintiff also claims
Claims
ownership
adverse
by
possession.
adverse possession.
Alternative case, my main case was that of oral heba.
Will any sensible person make a declaration? No, I don't think it's your case.
Yes,
Whether
plain case.
alternative
Yes,
or
yes,
not.
yes. Plain
If it
case
is
proceeds
so-
on that.
If it is so rock solid that it is on the basis of oral heba,
Plain,
then why adverse possession? So that itself raises
plain,
a doubt, a
Plain-
needle of suspicion, a needle of suspicion.
plain case proceeds on that basis. But kindly see observation, my lord.
That is a problem because this line we have added
Yes. And
because you,
order 41 rule
adverse possession will not lie. So why you have, what is your pleading for adverse possession?
But not Millard, my main pleading is that of
May not,
very well.
that's really not the point. ও নিজে চেয়েছে এখানে।
প্লেনটা দেখছি।
Even if your case was dismissed ex parte.
Ex parte dismissal. Oh, trial court records nothing. Well, that is a
No,
judgment.
no, trial court records, 3-4 paragraph, he said everything.
Wrongly recorded, Millard.
He said everything. Appeal court may have write 20 pages, but four paragraphs sufficient. He has said what is going to be said.
This is the Millard plaint, Millard. Kindly see Millard paragraph 3 of the plaint. Paragraph 3.
Yes. Oral have acted upon no evidence. If you have an unregistered deed, then there must be some reflection that I have already. What was the necessity for an unregistered deed then?
Kindly
There
see.
must be some, sorry.
On kindly see Millard this paragraph. On perusal of the oral heba which was reduced in writing in
Sorry,
page number
sorry.
2 of the said written heba. Kindly sees Millard this. Kindly sees Millard. The possession, therefore Millard possession was handed over. Court records that of the suit property to him so that he can construct his own.
Where is the unregistered deed of Heba?
I have annexed, Millard. I have annexed. It is there, Millard, in the application page 10, Millard. Not page 10, it starts from page 7. Court records that. Purpose recorded, possession handed over recorded.
একটা কপি দিয়েছে না, একটা কপি দিয়েছে।
It is annexed, Millard, in the application.
Annex করেছে application-টা। তো কাজী কায়েম আলী একটি লিখন থাকা আবশ্যক বিবেচনায় পশ্চাৎ 23 তারিখে উক্ত মৌখিক এবার পত্রদাতার বিষয়ে
এটার কপি আছে?
পারিবারিক এবং হেবানামা দলিল বাদীর নাম বরাবর সম্পাদন করিয়া দেয়। নানা কারণে
To Abdul Rahim.
What is the meaning of Borjati? You know?
What's the meaning of Borjati?
No.
At the highest, give you a right of possession, nothing more than that. No ownership.
No, kindly see, Millard,
No ownership.
the 149. Kindly see 149. What are the ingredients?
See, you yourself was in doubt whether you became the owner of the property by name of Hebanam, correct? Now, it is extremely unusual if an oral gift is there, then there will be followed by another deed. Yes, very well that under the Mohammedan law, you don't require it to be registered.
Registration.
But there has to be reflection in the deed that previously I have given this oral heba to them. Now, I am also recording this fact. Where is that recording of the?
Court has recorded that.
Forget about the code, deed.
Page 6. That is page 6. Court, appeal court's order.
I want to see the deed.
Deed. Yes, page 8, Millard. Page 8 of the Millard, page 8 of the application. Kindly see. Page 8, the deed. Kindly see the second আমি সম্মতি ভক্তি আমার নিকট হইতে আমি প্রাপ্ত হইবার এইরূপ আমার বিশ্বাস ও পূর্ণ আস্থা আছে, সেই রকম তোমাকে আমি সবই ভালোবাসি ও স্নেহ করি। আমি আমার নিম্ন তফসিল বর্ণিত সম্পত্তি যাহা তোমাকে আমি ইতিপূর্বে আমার ব্যবসার উদ্দেশ্যে অনুমতি প্রদান করিয়াছিলাম,
Permissive.
পারমিসিভ ইন দি
Gift. Not a gift.
করিয়াছিলাম।
Permissive, অনুমতি.
Yes.
In a gift, there cannot be an অনুমতি. Take down.
So, kindly see paragraph
Well, I am for the appellant, my lord, in terms of your lordship's direction, the stay application and the memo of.
I'm on behalf of the respondent, all the respondent except respondent number 6.
What is matter?
The matter, lord, the appeal was
Appearing for all, excepting respondent
Except
number
respondent number 6.
a suit for declaration of title and my lord, injunction was filed. The learned trial court dismissed the suit, holding that neither of the parties could produce title deed. But is our case is, lord, originally Brahmottra property was given to by on rent by the original landlord. Thereafter, my lord, Sundarban operation, our names were recorded. And in 1953 Estate Acquisition Act, lord, as riot, our names were recorded. On that basis, we filed the suit. Lord, they are, lord, trying to dispose us. Thereafter, my lord, suit was dismissed. We preferred an appeal. Lord, during lord COVID period, there was certain irregularity, record was missing, we could not track, and accordingly the matter has been dismissed for default. Why we filed an application under wrong caption order 9 rule 9, it should have been order 41 rule 19 for readmission of the appeal. The learned appellate court has dismissed the said application, holding that it is not in form, and also that the petitioner has failed to say whether any application for limitation has been filed or not. No question of limitation because it was dismissed for default on 11/11/22 and a restoration application was filed on 12/12. That is not within time. Therefore, Lord, this should be restored and directed to be heard on merit.
thing is this was dismissed as you have not failed to take any steps.
Lord, yes.
As you have failed to take any steps, that is
Yes,
the
Lord.
order.
Yes, Lord.
If you fail to take any steps to make the appeal ready for hearing, our rules also provide for that.
Lord, appeal is ready for hearing. Your Lordship, only some applications are pending.
Title appeals such as are dismissed by this court on 11th November
Yes.
for taking no step by the appellant
Yes.
after taking opportunity to them.
Yes.
Rule 9.
Lord, from the order sheet, it will appear that even the case record was not available. It was missing for 1 year. Thereafter, it was not placed. We could not make track. Lord, this is the COVID period. Lordship, can you consider that let there be direction within a specific time limit, the appeal may be heard on merit.
When did you file the restoration?
Lord, on 12th. 12th.
It was
Lord,
dismissed,
11th it was dismissed. Within a month it has been filed.
so that should be decided. We direct the appeal hearing of the appeal.
Yes.
Straight
Money.
up.
Well, if my learned friend is arguing the final hearing, then my lord, I need some time, but I will request Lordship to take it after Baker.
It's a very short point, Lord.
No,
What point?
substantial points of
Order 7 Rule 10, Order 7 Rule 10 was allowed by
Well,
misinterpreting Section 9.
kindly see on facts. Yes. Well,
Settled law. It's settled law.
well, kindly hear me out. This is a case where one
We know.
No.
We have discussed the law. Have you seen the judgment of 25th, our order of 25th August?
Yes. Well, kindly.
If you can say anything contrary to it.
No, I am saying something else, my lord. If your lordship sends this back, my lord, again, my lord, that hearing remains, my lord.
No,
My order.
Lordship will decide it. Why will send it back?
Absolutely not.
No, my lord, there are other points in the order 7 rule 11.
It should remain. This
Then,
point will go.
my lord, kindly.
So this point, if you have any
That
other
is what I
point-
am saying. That is what I am saying, my
No,
lord.
if you have
Kindly
any other
take up
point-
all the points. Kindly take up
Accepting this point, of course, this is decided.
even on this point of on facts, my lord, on facts. He is, my lord,
This point can also be framed in the suit, no problem. If
My
you
lord, I'm
want,
saying-
but you deliver your witness.
well, I am saying, kindly hear me out once. His contention is the summons, a warrant of arrest.
That is conclusive.
My lord, kindly hear me out only. Let me finish my sentence. Warrant of arrest was served upon him under this jurisdiction. But now, my lord, I have never heard of a warrant of arrest. A summon is served. A warrant of arrest is not served upon any person, my lord. His whole foundation is on that basis. How can a warrant of arrest be served on a person, my lord? And his
Warrant of arrest is to be executed through police agencies.
Yes. So it was executed here because he was here.
Well, it is not his case. He says his
That
specific
is my case.
it is his specific case.
Order 711 is yours.
My lord, his case, he is saying that it has been served on me. Kindly see his statement.
The warrant of.
Kindly see his statement.
কি বলছে? বুঝতে পারছি না।
Who served warrant of arrest upon him?
He has not said anything.
That is
Warrant of
mistake.
something is implied. Warrant of arrest will not certainly
My lord,
fly and
he makes a specific statement. Kindly see page.
I've annexed
6.
the warrant also at page 45.
warrant is also annexed.
At page 45.
That is my exact issue, my lord. How can a warrant of issue be served on a person? It is never served on a person. And it is addressed to the police officer at,
Lordship will find
not
the-
even on a
the
police
address-
officer at Kolkata.
address
Not
is
even
of
a
Salt
police
Lake.
officer at Kolkata, my lord. The warrant is at page 44.
44.
It is not addressed to any officer in Kolkata.
No, kindly see the page 45. It's Obhijit Gupta, the plaintiff appellant, resident of Salt Lake. That's
That
where
is
he
a
has been served.
translated version. My lord, can you see 44?
Resident of Salt Lake. So it was executed here.
My lord, he was never arrested.
here.
He was never arrested here, my lord. He opted.
It was executed here.
But warrant was not
It
executed.
was
That's
served
my
on
whole
him.
issue.
Here he applied for anticipatory
How does-
bail.
how is it-
Anticipatory bail was given by
How
the
is it?
by the Barashat court.
Basic question, my lord. Basic. A warrant of arrest is executed
No,
through a
no.
police officer.
Go through the contents.
Yes, my lord.
Statement of crime falls under section 409 IPC. You are hereby directed to arrest the said accused.
And this
Obhijit
direction is upon
Gupta and to it is addressed to whom?
the officer
Where-
in
where-
charge, my lord.
Where is
My
that?
lord, kindly,
Where is that?
Nyalay,
She
Khan,
requesting ASI to please comply. with
And
the
it
above-
says either where the warrant is served or the defendant resides.
my lord, I am reading the Hindi version, my lord.
No, that, section
By
19.
section 19,
My
if
lord.
you go by section 19 of the CPC, it gives jurisdiction to two courts, either where the process has been served
Yes, my
or the
lord.
defendant resides.
Or where he has suffered the damages, my lord.
No, where the damages suffered is not the issue. Where the wrong is committed,
The wrong
courts have held the wrong is committed where process is served. Here process includes warrant. That's a special bench judgment of our court.
The police came from Jaipur, I think.
that he has not pleaded.
I am not required to
That
plead
he
that.
has not
Can you
pleaded.
say? That is a police can. If it is
My lord.
eligible offense, police can come to the
Yes, it
beyond,
can.
beyond their
But did the
beyond
police,
their state.
did the police come? Did they arrest him from here?
And they
Not
have
the
to
averments in
and
the
should
plaint have to be taken as
take
true
on
and correct
transit
today.
remand, should take on transit remand.
He obtained a
Yes,
transit
Jaipur
bail.
from
Yes, my lord.
Police came from Jaipur. He has to go to, after arresting him, he shall go to Chief
I
Judicial
understand.
Magistrate.
My lord, my
Salt Lake.
pleading is
My
at
lord,
page
can-
76, paragraph 32 of the plaint.
Kindly see page.
Page 76, paragraph 32 of the plaint.
See, the impugned order. See the impugned order,
Yes,
Mr. Dasgupta. The plaintiff was served with a warrant of arrest issued by the learned assistant judge at his residence.
That is his claim. That is his claim.
So at the stage of this, the court has to accept this statement. If you accept the statement, then it's section 19. Stay down.
Well, not only that, my lord, there are other issues.
Sorry.
Then, my lord, kindly leave.
This order goes. Stay down. Stay down.
But
Is
we
it
will go by
equity or
his plaint,
whatever
my
is
lord.
caused
We
here?
will go by his plaint. He says my injury has
Whatever
occurred.
is there, what is said on the basis of the plaint, court has jurisdiction. Absolutely. Next.
Serial number 9.
My lord, serial number 9, my lord, I beg to appear on behalf of the appellants. My lord, I was praying for your lordship's leave to appear virtually. My lord, pursuant to your lordship's order, my lord, we have cleared our defects and the copies has already been served. Unfortunately, I'm carrying the, my lord, affidavit of service with me, my lord. It is there with me. It is not there on record before your lordships.
Today the appeal has now become infructuous.
No, my lord.
Yes, because the interim order was still 4th July 2025.
No, my lord. Kindly takes the my lord order, my lord. That is that the order dated March 2nd of.
But there is nothing wrong with the judgment.
Yes, my lord.
No, my
I am
lord.
the
My lord,
respondent.
I tell you, may I place the case, my lord. My lord, it is an admitted position, my lord. This is an unpartitioned property suit for partition. We are the defendant number 1, 2, and 3. And it is also an admitted position in the plaintiff's case as well as the order passed by the learned trial court, my lord, that there were arrangements made
At
and
this stage, we don't find a reason.
my lord, kindly takes the my lord, inspection report, my lord, once, just for once, my lord. Kindly takes the inspection report as page 29 of your lordship's stay application.
The report says
But that inspection report suggests, page 31, there are existing constructions and we are making a this is an old, my lord, kindly takes page 31. Every other property, every other persons are holding their shares of property and having residential houses, including us. That is Teenage Chala 1. My lord, kindly takes new construction is being taken place. But why we are agreed by this order, my lord, with regard to the non-alienation, we are not saying anything. But our construction of a new residential house has been halted, my lord. And we have valid sanction plan from the authorities. It is just that it is an partition amongst ourselves.
But if there,
Constructing his property in our land, my
Not
lord.
pleaded anywhere.
My lord, my lord, there was a read which was disposed of on.
you see that if he is in possessions, wherever he is in possession.
My lord,
he is not in the possession. He just trying to occupy the whole property and.
No.
If he is in possession of a particular portion, if he is in possession.
No, that portion not belongs to him, my lord.
Belongs to him is a different issue. Suppose I am in possession of this particular property, maybe illegally, as a co-sharer, not illegally, as a co-sharer. You may have also a right to offer this. And while in my possession, I am trying to, because of various reasons, I try to raise a construction in which I am living. So I may be allowed without creating an equity. I may have to demolish it also.
My lord, he is trying to evict me from the
No.
land, my lord.
It is his suit, not me.
Here, there was also, I was also living there, my lord. He evicted me and then constructed the
But
same
if you have been evicted, did you take any steps for restoration?
No.
My lord,
no, what the commissioner's report says.
But this report suggests, my lord, that there are undemarcated properties and there are different houses at different places of that property of all the co-sharers.
My lord.
No, but if there is a sanction plan.
Yes, my lord, we have.
They are not allowing him to construct it in a vacant place.
My lord, for this disturbance.
And my lord, kindly sees the order. It order reflects everything, the plaintiff's case
My
also.
lord, kindly see the order dated 4th July 2024, my lord. Kindly see
My lord, kindly sees page 25. My learned friend is referring to.
You are disturbing.
My lord, I tender my apology. I tender my apology.
Yes.
My lord, please see page number 25, my lord.
Page number 25. Yes, what happened to this?
My lord, there is specific direction upon
Upon the
Pradhan
Pradhan.
to mediate the matter. Several meeting called for, he never cooperate and never attend the meeting, and he continuously constructing the same and creating disturbance.
No, but it says that Pradhan, if he decides that there is an unauthorized illegal construction, the Pradhan of the concerned within such to the parties shall transfer the same and refer the matter to the subdivision officer. The jurisdiction then shall take up all necessary matters immediate effect. So long this thing is there, we cannot pass an interim order.
My lord, may I say this, my lord, with regard to this order? My lord, my lord, your lordship is well aware of section 23(5). My lord, this is a proceeding which is, my lord, my lord, it was a, my lord, proceeding triggered by the private respondents by filing of an application before.
But the proceeding has already been initiated.
My lord, there is no outcome of this proceeding because the Pradhan, the Panchayat.
Different issue. We cannot allow you in pendency of this takedown.
My lord, the Pradhan himself has, my lord, kindly takes the sanction building plan. My junior is handing over. My lord, kindly takes. The Pradhan himself has, my lord, given the sanction building plan.
What is the outcome of 4th July 2024 order? Then
My lord, I am bereft of this instruction, my lord.
In view of the order at 4th July. Dismissed. Convention allowed. This side.
There was a delay of 15 days, my lord.
On side, yes. Yes, delay condom.
Grateful.
Any urgent order 41?
No, next one is mine. My lord was pleased to direct me to file a supplementary affidavit to describing the all facts. Regarding that matter, the wife has come later after 10 years. And what was the
yes,
deal?
call that matter. Call that matter.
Number 10. Lordship, this matter.
Any urgent matter in the appellate side? So if you want us.
Everybody will say that.
But have you served them?
No, my lord, I could not serve.
Stay down.
This matter, my lord, your lordship directed me to file a supplementary affidavit and to serve all the copies upon the respondents, my lord. But that I have done, my lord.
In this matter, my lord, they have paid for appointment of a receiver. They have made an application for appointment of receiver. I shall file affidavit in opposition against that application. Otherwise, my lord, there are so many facts involved in this.
So receiver application was dismissed. Receiver application was dismissed.
No. Yes, my lord, receiver's application was dismissed. Before the land court.
That is, they paid for He has prayed for
Yes, this was the
appointment of
division between the mother and others has been, that is, oh, I remember the
But I
fact.
have been ousted. Malad, I have been ousted.
Take down, take down.
Malad, I have been ousted. Malad, your lordship kindly see in the
No,
impute.
no, এটা
Malad,
ভাবেই করে দিয়েছিল।
Malad, your lordship kindly see. No, my lord.
Take down, take down.
Malad, your lordship kindly.
Page 43.
Please one at a time, please one at a time. What is
Page
the order?
43, my lord, your lordship's order has been annexed supplementary affidavit, my lord. Page 43. That is diyeছেন তো?
হ্যাঁ দিয়েছি দিয়েছি
Page 43, my lord. My lord, supplementary affidavit, it has been annexed. Annexed at J.
কত পাতা বলো তো
Oh, this was on unreason, that is the thing.
That is in respect of schedule A.
মানে one of the schedule মানে that has been mentioned in the impugned order.
Still, it wasn't, second appeal was an order of affirmation,
Yes,
correct?
yes.
So the first trial court's order remains, we have not disturbed that.
Well, your lordship did not.
First order, appeal, trial court's order, we have not disturbed.
Well, that is
So
true, my lord.
decree remains.
But madam, that has been merged with the order of the appeal court, my lord.
Correct.
That is your
But appeal court, we said the appeal to be heard. That does not mean that the trial court decree has gone.
But I am not saying that, my lord. Your lordship has been pleased to stay the all further proceedings of the execution, my lord.
Yes, the execution we have stayed.
Because, my lord, the trial court order has been merged with the order of the
Take down,
appeal
take
court.
down, take down. Now let the trial court decide on this. Take down.
Your Lordship, we have been served with the appeal only yesterday, and we are yet to receive instructions.
They are controlling the delay.
Your Lordship, we plead for an opportunity to file affidavit since it's a significant delay of 275 days.
Not significant. বের করতে হবে। Yeah, minute. So it has to be on a substantial question of law.
Right.
So at this stage, you are not required to be heard at the substantial question of law. Only if we admit the appeal, then your turn comes. Now, what is the substantial question of law?
I. That is, my lord, page 8, my lord, page 8 of the stay petition, paragraph number 7.
Your Lordship, if before that we could also bring to the notice of your Lordship that the appeal is below tax effect. The tax effect for this appeal is 52,96,000. It's on
Milord,
page 7
Milord,
of
we
the-
have stated in paragraph number 6, Milord, there is a CBDT circular, we have mentioned that, Milord, it says, Milord, when the, Milord, decision of the, Milord, tribunal, if, Milord, it is substantial question of law is decided, which is, Milord, against the revenue, Milord, in that case, Milord, irrespective of tax effect, Milord, we can file the appeal. Paragraph number 6, Milord. ডকুমেন্টগুলো কোথায় হাইকোর্টের?
That's what is wrong. You see that the compensation they received due to the situation prevailed at that point of time in the case.
Milord,
Yes, so cannot be said to have walked out in the normal course of assess business.
Milord, subject to lawsuit correction, Milord, there is a our court judgment. Milord,
You first forget about the judgment, come to the reality of it. Please don't go to the judgment. We always jump to the judgment.
Milord,
First, we'll assess the facts and then come to the
Milord,
judgment. So this
but-
cannot be treated as how it could be a capital in nature. This is the nature of a compensation.
Milord, this is, Milord, Milord, the tribunal says, Milord, in the COVID period.
Answer our query. How it become capital in nature?
Because, Milord, this is a future loss. It is not that they have occurred loss. It is a future loss that has been, Milord, assessed. It is not that, Milord, in the COVID period they have occurred loss. It is a future loss. That loss has been, Milord, considered and given. It is not that they have occurred loss. It is a future loss.
So you mean to say that no actual loss was suffered due to the premature termination of the assessment?
Milord, that, Milord, in this case, Milord, the Honorable Division Bench, Milord, remanded the back.
Please answer on facts.
My lord.
This factual is correct. If the factually this is correct, then what is the wrong with the judgment?
Milord, wrong is that, Milord, the Honorable Division Bench earlier occasion remanded back the matter before the tribunal and specifically directed the tribunal to, Milord, decide the issue. Your Lordship, kindly see, Milord, page 36. Milord, it is specifically says that the tribunal is required to be, Milord, decided whether this is, Milord, capital loss or not.
But this was according to the tribunal.
The
Appellate tribunal has relied upon the decision of the apex court in the assessor's own case. Where is that decision?
Milord, decision
In paragraph 15.
Milord, we have said, Milord, that is, Milord, distinguishable. Milord,
You may say, but let us have the look
Yes,
at what
yes,
it
Milord.
says. That is your interpretation. There has to be a distinction which has termination in the ordinary course of business and termination resulted due to unavoidable circumstances, like maybe act of God or something like that. So if it is kind of an act of God or something like that, then this cannot be equated with a termination from the ordinary course of business.
Your Lordship, Your Lordship, if we may
May I submit that, Milord? This is a, Milord, this is a loss that is, they have not occurred actually. Milord, this is a loss that is estimated may they have occur in future.
It will be taxable provided it's a revenue.
Yes, revenue
If
income
it's a
taxable.
so if it's a capital receipt, it's
No, not taxable.
So this loss, what is occurred, cannot be treated as a revenue.
Because yes.
So it has to be a capital receipt.
No, but our contention is that this is not a capital receipt.
That is your contention.
That is why
It's your contention.
a contention of the assessing officer.
But what the
Your Lordship kindly
what
see.
the commissioner said.
CIT appeals also affirm the order of the assessing officer. You have to kindly see page 13. Page 13 of the stay petition.
Your Lord,
The purview of your Kettlewell Bullen.
My lord.
Kettlewell Bullen, whatever the principle laid down, it comes within that purview.
No, your subject to your kindly see page 13.
No, are you disputing that it is a cancellation of an agency or rather cancellation of an agreement? It's first condition. So it's a cancellation of an agreement. Secondly, the trading structure of the assessee is impaired. There the trading structure is impaired. Thirdly, such cancellation results in loss of what may be regarded as a source of assessee income. They have a source of income from there. So whether it will normally follow that there will be a loss. The payment made to compensate for cancellation of the agency agreement is normally a capital receipt.
That is the contention of the assessing officer.
No. Forget about the contention. We go by the limbs.
That's why I am placing the page 13 of the assessment order. From it,
don't go by that. We are on a principle of law. Whether the situation, this one paragraph which has been said by the appellate authority, a judicial member and the appellate authority, if this factually is correct, then it becomes a capital receipt. It cannot be a revenue. In our opinion, the premature termination of the assistance agreements due to Iraq's invasion of Kuwait and the subsequent sanction, which resulted in the assessee receiving compensation from the United Nations Commission, cannot be said to be occurred in the normal course of assessee's business. It would not have been in the normal course of business. It is a kind of a compensation on the account of the expected loss at the highest. Because this is a premature.
Premature, yes.
This is a premature,
yes.
so obviously my income is affected. So in my income is affected means I will not be able to earn the revenue. So whatever I get is a capital receipt in the sense of compensation.
Now, there is a judgment of our court also, this judicial court also.
Our High Court judgment
Yes.
was set aside by the Supreme Court.
No,
in this matter, 1994.
Yes, but our
High Court. See, we go by the Supreme Court judgment.
But this Supreme Court, this judgment is factually different. The factually
we are not on the factual. We are on the principle of law. Fact will come later. First principle is this: that whether it has to be a revenue or a capital receipt.
But our contention is the revenue because it is a revenue? Because it is a future assumption because the assessee did not occur the loss.
You mean to say that in the ordinary course of trading business they could have also suffered loss?
Yes. It is not that we are in a hotel.
What would be the element of a premature termination of an agreement, maybe by reason of a statute or by an act of God? What would happen? Will it be considered to be a receipt or a capital revenue or a capital receipt? Revenue would mean that my earning capacity. So my activities generate a fund which becomes my revenue. So this I am prevented from carrying out my activities. So generation of revenue is loss. So it cannot be a revenue. So what I receive is what the Honorable Supreme Court has said: cancellation results in loss of what may be regarded as a source of assessee income. So this is kind of a notional thing. That the assessee, if the assessee could have performed this kind of trading activity, they could have earned.
Could not.
But principal assumption is this. So it's not it's a favor of the assessee because reason is there. I made a substantial investment. Return of investment is stalled. I am not getting my return of investment. So if I'm not getting my return on investment, so the presumption of loss must be there inherent in it.
But that has to
because I am not being able to carry out my thing.
Well, that has to be looked into.
Take it out.
May I submit the assessing of your lordship kindly see page 13 of the assessment order.
No substantial question of law involved.
Then your lordship kindly take up the matter after vacation because the principal
substantial question of law we have to formulate. By after vacation we cannot change our mind.
No, I can place the case the better way. That's why I'm
better way.
Yes.
Place it better way.
No. Your lordship kindly take the matter then after vacation. Kindly not decide today.
You want your senior to argue?
No, I will argue.
Your lordship, if you may submit just two.
Not at this stage. You are not required to.
I will argue. I will satisfy your lordship. You will kindly give me 1 day time.
Mr. Dotto is not coming, so you are taking the time.
No, I am not. I will do the matter, my lord. I will do the matter.
The Lord Councillor. When we grant stay, if we admit and then only. As of now, we are possibly not admitting, yes. Yes, next matter.
My lord, I appear on behalf of the respondent, my lord. My instructions are it's not been served, my lord. There are two GAs. My instructions are that my client has not received a copy, my lord.
You have not given. We have
Lord, I
given
have-
the delay for the.
My lord, I don't know how many days delay, sir.
44.
My lord will kindly give me a chance, my lord. Whether
44, you are there. We have seen the grounds. We have
My
seen the
lord,
grounds.
my lord, we have no idea from which order. My lord, 244 days. May I come back after vacation if Mr. Bhattacharya could wait for
No,
244 days, my
you have
lord, just 1 month.
Paragraph 2, they have explained. Right now.
My lord, unfortunately, 181 days delay is there, my lord.
Who is the other side? Have you
Lord, we
started?
have served, my lord.
Service is complete.
Yes, my lord. Delivery is there showing, my lord, it has delivered.
Yes, yes. Deliver করেছে। আচ্ছা। ওই আগেরটা Yes, yes.
But I'm appearing for the respondent.
Lord, I'm appearing for the applicant.
You are paying for?
Applicant. For the applicant.
Oh, this matter we heard, I think so.
This matter has been heard, my lord. Similar facts, the assessment here is different, my lord. Similar facts, my lord. Lordship has passed this order, my lord. This is the order. Same facts, everything. Assessment here is different. Combined order, tribunal's order is a combined order. Lordship will find a combined order.
Let the can GA1 be
But if your lordship will kindly see
purpose of today, the hearing can be done by my senior, my lord. Not a
your lordship will
He doesn't want that the matter get dismissed. in absence of a senior.
Yes.
So today your senior has abandoned you. ডিলেটাকে কন্ডোম করে দাও on the prayer of the any urgent matter before the vacation, because tomorrow we'll not take any tax matter. So any urgent matter if you have,
There's no urgency.
then can we all fix it after?
After the
We'll try
vacation,
to have one day, full day if possible
Yes.
for the tax. So let's see, maybe we'll be able to organize.
Single bench only on Tuesday, and Tuesday he's not taking on the revenue matters. Tuesday or subject to correction on
So single bench is not taking up on Tuesday, correct?
Tuesday, yes, madam.
Or Thursday.
And Friday. Friday is only application day.
Friday is difficult because we have all, so we'll try to
Tuesdays-
do it on a Tuesday.
Tuesday is
So
better.
we'll give this revenue matters preference.
Yes, ma'am.
Most of the matters are, I think, decided by.
Yes,
by-
almost, my lord. Almost. The issues are already been
Whatever-
decided by.
I would request all of you that the matters which has already been decided,
Yes, madam.
unlike that what he said that regarding the Oberoi matter, so.
Yes.
No, those are different kind of matters which will always come before my lord.
Yes, ma'am.
No. See, we will want this transparency from the advocates, whether you will file an appeal or not. We decided. If it is not decided, not decided. Very well. So that will help us, because this law is now more or less well settled.
Yes, ma'am. Almost.
For me, it may be little.
Yes.
No, substantially crystallized. But what my lord will find now is the act is changing very dynamically.
Dynamic.
So-
So there's amendments made and
If some are to be admitted on the basis of whatever you decide,
yes, ma'am.
you just give us so that we can go through it.
Yes, ma'am.
And which has already been decided, those appeals can be disposed of. For example, the previous matter.
We
We
communicate
have
up
already
the
decided, so we are just to dispose of the matter on the basis of earlier order. So please go through and give us a one-pager note for each of the matters.
yes, ma'am.
Before we come, we look into it and then we dispose of the matter.
Absolutely. We'll communicate to all the members of the bar.
It should not take much time.
Yes, ma'am.
Some matters will, of course, but. So, happy Puja.
Happy Puja vacation.
Happy Puja vacation.
Happy Puja vacation.
Preferably we keep it on all these matters on 28. 28 তারিখে না? 28 অক্টোবর আগে আমরা রেভিনিউ ম্যাটার
Suggest
can
one more thing. I suggest the earlier bench, we were benefited by a WhatsApp group prepared by the court officers. And we used to get at least in the original side, we used to get information regarding the next day's list by 4:30 or 5 o'clock on the earlier day.
Same thing can be done.
If this can be instructed.
Well, great, man.
What?
Well, I'm seeking your lordship's kind leave to file this appeal, my lord. Oh,
Appellate side, Delhi list, serial number 1.
And I am appearing in the matter.
Contempt joint logistics.
Joy Hind.
Petitioner, this is contempt petition. Thank you.
Blood.
Item number 4.
Please take.
Evidence service.
No, no. Act against.
Very well. So you are for the, so you want to rely on some additional documents?
Yes, my lord. That was filed before the Honorable Supreme Court, my lord. And those documents will prove that two of the successful tenderers, my lord, who are given the work order, they have forged the RC, that is the altered,
Have you filed any application for additional evidence?
my lord.
Have you filed?
Those additional documents were directed, we filed before the Honorable Supreme Court. We were directed to file those documents before this Honorable Court. The entire document,
Along with additional documents. Have you
yes,
filed
Lord.
it?
We have filed it, my lord.
ওখানে file করেছে? RP নাম্বারটা কোথায়? রিভিউ নাম্বার তো বলুন। So where is this? Can 2 and can 1? Can 1 and can 2? Very well.
Can 1 and can 2, my lord, one is for section 5 and another is for stay.
কপি আছে, কপিটা এসছে আছে তো? Read me, Lord, would not like to trouble your lordship, Lord, on this side of the vacation. There's only one problem. The writ petition, my lord, copies of the writ petition are not on the file. And we are essentially saying that there was a previous binding judgment of a coordinate bench, which was not considered because it was not placed at the time of consideration of the matter. In connection with the interpretation of an integrity pact in the tender, my lord, of the railways. Now, my lord, insofar as that similarly worded pact is concerned, a division bench of this honorable court had held that even if there is a previous misdemeanor prior to 3 years, but the effect of that comes within the period of 3 years, that would also be considered a disqualifying provision. That was not so done in the instant case. Hence, my lord, the writ, in the writ petition, my lord, it was found that the writ was beyond the territorial jurisdiction, yet findings on merits, my lord, were advanced. Lord, at this stage, my lord, I was humbly beseeching if your lordship permits us to withdraw the writ petition. Withdraw the writ petition and to file afresh, because it has been also held in the writ.
But Mr. Banerjee, is a review application maintainable by change of advocate?
Oh, is this a change of advocate?
Yes. You are not there when the main matter was heard.
Oh, but I am, my lord, of course, the advocate on record.
I have filed a.
You are there.
No, I wasn't there. I wasn't there. I will go by what the record says, my lord, automatically.
The Honorable Supreme Court is deprecating this practice.
Then, my
Review
lord, I should.
applications by change of advocates. So a set of advocates have argued in one manner. By changing the advocate, you will be taking new points in the review application.
No, well, that, my lord, I can assure your lordship, my lord, if your lordship says that, I can retire, because I would much rather, my lord, protect propriety than a particular review. Reviews will come and go.
You are aware of those decisions of the Honorable Supreme
Yes.
Court.
But if you have not argued any point, then there cannot be any error apparent on the face of the record.
Question is, the question is now,
And it should be deemed to
Netaji
have
Subhash,
been not argued.
yes, no. There was a point, a division
Has
bench,
to be an error apparent on the face of the record.
the
There's no error apparent on
the
the face of the-
non-arguing of a.
Whether a particular clause has been misargued, non-argued, or non-interpreted, misinterpreted, we are not on that.
That clause has been argued.
Yes, so
That
this
submission
clause has
made.
been argued and
A coordinate bench's judgment has not been
different issue.
placed,
One
which
coordinate
was binding on this honorable court. Binding on the honorable division bench, we took up the matter. The same honorable division bench, in a connected matter, interpreting verbatim the same clause, said that there is latitude for the purpose of interpreting the disqualifying provision beyond the period of 2 years within 2J of that particular integrity pact, because if it emanates earlier and then it is subsequently put into trial. Lord, there is another ground, Lord, a very humble submission. Lord, we were permitted, it was held that the petition was without jurisdiction. It was filed, my lord, in Calcutta, though, my lord, the tender was floated in Delhi. And, my lord,
But it is wrong. You go to the Supreme Court.
my lord, no, I am only on that. I am accepting that. The single judge held that. The honorable division bench did not have.
Any reason to.
My lords, kindly, my lords. The honorable division bench held, my lord, did not go into the question of jurisdiction. Kindly permit me, my lord, to withdraw the writ petition and to present it in Delhi. Only this much. It was my folly to present it here. Withdraw the writ petition. There's a finding of Justice Shampa Sarkar.
How can you allow this in the review?
Lord, kindly, my lord, comes to the impugned order, the order of the single bench just once, my lord, kindly. It was held that this is without jurisdiction.
You have preferred an appeal against a single bench order.
Yes, I preferred an appeal.
Appellate court has disposed of the appeal.
Appellate court have disposed of the appeal.
You are asking for a review.
I'm
Now
asking.
you are saying that you should be allowed to withdraw the.
Tell you lordship why. Jurisdiction and merits cannot, my lord, coincide. We had argued jurisdiction was held against us. If jurisdiction is,
yes.
So we are
accepting the reasons assigned by the learned single judge are perfectly justified.
Yes.
It does not call for interference.
Therefore, the jurisdiction has been held against us.
Correct.
Then all findings on merits that are there, should therefore, my lord, we should be relegated to the appropriate jurisdiction to urge that point. Holding it against us, merits can't be held in, my lord, held against us. My lord, kindly see the Justice Shompa Sarkar's order just once. It is a clear finding that territorial jurisdiction is wrong, and then goes into the merits. That has been upheld, my lord. In review, the only point I am raising is, my lord, if jurisdiction has been held against me, kindly permit me to go back to Delhi and, my lord, to file a writ. Otherwise, my lord, this will, my lord, operate as res judicata in a forum which does not have jurisdiction. Only that much, my lord, so that I can be permitted to file a writ petition, and these observations will not be binding on me, because it has been passed by a forum without jurisdiction. That's held by Justice Sarkar. It's not that as if that point was.
Other side. Have you served the other side?
I'll come back. Or your lordship can say that, my lord. If your lordship, I'll come back. I'll come back.
Observations are there in their
Yes.
absence.
The
Limited.
appellant is the
was mortgage in respect of a property which is not my property. I came before this honorable court, and this honorable court says that there is an alternative remedy and go before the tribunal, my lord. Thereafter, my lord, I have, my lord, obtained the certificate after dismissal of the, my lord, appeal, intra-court appeal. I have obtained the, my lord, certified copy of that particular deed. I have seen that it's completely different. Even the area is different, flat number is different. Which is, my lord, Annexure D of my CAN 2. Position notice টা দাও। Position notice টা। কি order is?
Have you served them?
My lord? Yes, my lord, sir.
Calcutta. 736 days. 736 days negotiation. 4 years old. Time coach. There is a settlement.
Again, I will serve, my lord. Again, I will serve, my lord, because I have already served.
You have served for, where is the evidence service?
Again, my lord, I can give a notice to them. my lord.
No, it's a copy to you. Book to deliver. It's a forged deed.
No, no,
Or
I'm
what
saying
this
that,
is?
my lord, the my lord bank has mortgage in respect of flat number A. My flat number is GA. That is completely different. Kindly turns to my page number 89.
The deed is forged.
Which one?
Your case is that the deed is forged. You are not saying what you are saying is something different from what you are saying now. If the if the mortgage deed does not describe your property is one thing, but you are saying that the deed is forged.
After obtaining this, my lord, after obtaining this certified copy, I have found that this schedule is completely different.
There is not a forged
No,
deed.
this is not.
But you said it's a forged deed.
No, no, it is not. That is not my, my lord.
Paragraph 5. We are not reading from.
Paragraph of my writ petition.
No, your petition.
That is my story of the writ petition, my lord. That is. Subsequently, I found, my, that's why I said, my lord, my review application based on, my lord, discovery of this, my lord, deed.
The tribunal.
No, my lord, I have not.
Why not?
Because, my lord,
What you are saying before us, because your this right is being protected.
my lord, to kindly consider
Whether this mortgage contains or not,
that is with my lord. What has fallen from your lord?
that is already this
That is
liberty,
the
that liberty
tenets
was
of
given to you in 2023.
it is the tenets of the order. But thing is that, my lord, after getting the, my lord, that is the, my lord, authorized officer exercise the power without jurisdiction, beyond the jurisdiction.
Your case before the division bench was that you are a subsequent purchaser, correct? Subsequent purchaser unaware of this, so mortgage was created maybe after the property was sold to you. That was the original case.
Yes.
Now you are changing the complexion of the case here now. You have come out with a completely different story in this before us.
And purchase, my lord, mortgage.
That
I
is
have
the
not
case.
purchased from that person, my lord.
The
Kindly see.
bank should disclose the date on which the mortgage was created, and if the mortgage is created after the petitioner has purchased the property for valid consideration, the deed of conveyance. Then the Honorable Division Bench says, so all these reliefs was granted to you.
No, only may I let, kindly only one thing, my lord. Kindly, my lord, modify that order, my lord. Kindly direct the
Why
petition,
should modify?
my lord, petitioner to approach the, my lord, civil court, because my declarations, declaratory suit, my lord, he can do.
In so
That is not binding on me, that date. That is, my lord, the declaration. That declaration is required, one.
will not lie because the SARFAESI proceeding has already commenced.
No, I'll say, my lord, I'll say that that deed,
No, that issue can also be decided by in the SARFAESI proceeding if you show
declaration, my lord, my lord.
not a declaration. The SARFAESI court can proceed on the basis if there's a valid mortgage in favor of the bank. If the is on the date of the mortgage, there is no subsequent, there is no sale. And this mortgage, of course, is mortgage. Your sale cannot be when this property was mortgaged, it must be by equitable mortgage, deposit of title deeds.
My lord, kindly consider what
The original title deed
what happened in
must
this.
be with the bank.
My lord, order under section 14 passed in respect of A property, should be flat number A, but they affix the notice in my flat.
In a SARFAESI proceeding, suppose your property is sought to be attached, you have a right of remedy under the SARFAESI Act.
My lord,
That
then,
is
my lord,
precisely what Division Bench said.
my lord, kindly consider the one thing is that, my lord, kindly, this is my lord understanding of the law, that any person, I will not come within the purview of that.
Obviously, because your right is being affected. If your property is sought to be attached,
Any person aggrieved by the action under the that then
bank has
the
proceeded.
bank has proceeded, then it can, my lord, take the anyone's property. Then, my lord,
I have a judgment sitting singly that is also being followed by Justice Sanjeev Banerjee. Subsequent decision on that. This point has been clarified 2012 by deliver the judgment.
but my lord,
Not a person aggrieved.
But my lord, kindly consider the after, my lord, surfacing this deed, my lord, subsequently that deed, my lord, by which the bank has created the mortgage.
If in implementation, in execution of a certificate, the bank wants to attach your property, you have a right.
Right, my lord, suppose, my lord, I have, my lord, affected by the action of the bank if I am a tenant. If the surface.
Down for review. Are surface yeah.
There must have some, my lord, dual relationship with the bank. This is my humble submission, my lord. What is this? Yes.
See, any person, including a borrower.
My lord, anybody kindly connote in this way.
Including a borrower, that's what I'm saying.
Including a borrower, that is inclusive definition. But thing is that, my lord, any person
agreed by the
person
measures.
must have, my lord, with some dual relationship with the bank.
Sorry.
My lord, kindly only one.
Thoroughly misconstrued.
to approach the tribunal. Well, after discovery. Finally, my lord, give that report.
Serial number 4 is concerned, my lord. The order of his lordship has been complied with. How's that? Two-folded orders lordship has passed. Firstly, my lord, lordship was directed to send someone in the house of the petitioner, my lord, to assist him. That has been done. And thereafter, my lord, recommendation to the, my lord, central government, my lord. My lord, kindly takes page. Recommendation copy to the copy. Page 5, my lord. Kindly takes page 5 once, my lord. We have sent it to the, my lord, Secretary Department of so-and-so, North Block, New Delhi, on 12 September 2025.
Yes. My lord, actually, after their decision, I do not know what is the proposal they have sent. My lord, I have not been given a copy. May I just look into this?
Yes.
12th September it was sent.
Yes.
But when did they receive it?
I'm coming to that.
রিসিপ্টটা কবে করেছে সেটা কি
12th September it was sent to the Secretary Department of Personnel and Training. Now the proposal whether they have recommended from 2004 seniority to be decided.
বোঝা যাচ্ছে না কবে কি হয়েছে পেয়েছে কি বৃত্তান্ত
Lordship's order has been referred to and however, see Gurupada Konar sent a letter dated 3rd August 25 enclosed along with the enclosures addressed to the Secretary Department of Personnel and Training, Government of India, with a copy to the and this end concerning the case of Parveen Kumar IS for considering this year of select and all that. Then kindly come to next. After that, a letter was such and such, a copy was sent to the DOPT, enclosing copy of the representation of Sri Gurupada Konar dated such and such. The DOPT did such and such communicated year of allotment in IS in respect of Sri Gurupada Konar is 1995, which was communicated to Sri Konar subsequently. It is pertinent to mention here that while implementation of the Honorable Calcutta High Court's order dated 6th August 2021 passed in such and such, filed by Sri Gurupada Konar for consideration of his name for promotion to IS state government, neither decided for which select list year Sri Konar would be considered for promotion for IS, nor decided which allotment year of IS he would be assigned to. The state government was directed by UPSC Vide such and such, copy enclosed, to send proposal to consider him for the select list of 2005, and your good office has assigned Sri Gurupada Konar 1995 batch of IAS. Now, as per direction dated such and such, 11 September, copy enclosed, state government proposes and recommends considering Sri Gurupada Konar in the senior list of 2004. Yes. Now this is sent. Now what is our decision? This is the decision which we are compelled to take by the DOPT. Before my lord, I place that entire order which is communicated to us. May I just draw your lordship's attention to the order passed by your lordships. Kindly come to once in the list, page 70 of the contempt application. Page 70.
Process, the applicant. Oops.
May I say something, sir? That their proposal is that they have neither decided anything about seniority earlier, and in terms of your losses order, they are simply sending the proposal. That is their case in the report. Now, what is our case? I have been instructed to submit. No, I am just begging. Your lordships had been pleased to hold earlier that the seniority from the year 2004. But conclusive part is that when the juniors were promoted, that has been explained by us in the earlier affidavit. The list of juniors. Here also in the report, the annexures, 10 juniors seniority has been mentioned. And in such a case, I submitted before your lordship, subject to what your lordship will say. In such a case, if there is any subsisting cause of action, a fresh cause of action, they have to challenge it before the tribunal.
That will not.
And thirdly, your lordships are well aware that when there are two interpretations. Two interpretations, one which is to be followed, there is no contempt. And if there is compliance, even part compliance, there is no contempt. We have fully complied with your lordship direction. We have nominated him in IS. We have nominated in IS. We have directed the state government to give national.
The order was that he should be 2000. That is the ratio. The ratio of the decision was very clear. That we have also said in our.
Now, kindly come to page 74
No,
of the contempt application.
Sir,
The conclusive part is retrospective effect from the date when his juniors were promoted. Page 74 of the contempt application.
please read our observation in page 5.
Page 5 of the contempt application. Original order.
The author and counsel.
Page 72. Yes, we have heard the learned advocates appearing on behalf of the parties. The undisputed fact that has emerged from the materials placed before us is that the petitioner was born on January 3, 1950 and was below the age of 54 years as on January 1, 2004. When the vacancy for the year 2004 arose by reason of regulation 5.3 of the Indian Administrative Service Appointment by Promotion Regulation 95/55, he is entitled to be considered for promotion against the vacancies that occurred in the year 2004. The selection committee meeting was held on November 8, 2005 for the purpose of preparation of selection list for the vacancies which arose in the year 2004, could not have ignored the petitioner as he was admitted below the age 54 years as on January 1, 2004, when the vacancy arose. The cut-off date of January 1, 2005 for the purpose of filling up the vacancy for the year 2004 is contrary.
This is the ratio. Whatever this is the ratio, you went to the Supreme Court dismissed the assembly. So the ratio has to, this is the ratio of our judgment. So this may be some, in our conclusion, there may be some inaccurate, but conclusion must be read, just to be reconciled with the reason for which we have set it aside. And this was also the ground of challenge by you before the Supreme Court. So, yes,
The ground of challenge.
we may accept that there may not be a contempt, but this has to be implemented.
Lord, may I just subject to correction with great respect submit. The ratio that your lordships had been pleased to discuss earlier comes to the conclusion where your lordships had been pleased to record. This is the conclusive
That is why
part.
you may not have, that is why it may not be a contempt. But justice has to be done. What we have intended to give him is that paragraph. That has to be added.
Lord, may I just only submit this? 10 persons lists were annexed to this report. And had it been the case that we have not given him promotion.
That is not the point. Point is this direction has to be complied with. If that one person is left out, he has to be left out because this is clear in our order. We have said his case could not have been considered by a cut-off date of 1st January 2005. So you follow this, whatever the consequence, if one person goes out, he has to.
But would it be lordship's pleasure to allow me to read the last paragraph?
No. We'll say that this last paragraph has to be read along with this.
Exactly.
So if we have given him this benefit, we have not taken out that benefit from him. This has to be meant in the context. So that is why you may not be in contempt, as we said. But this is the main direction.
Direction, but what is the conclusion taken that your lordships kindly come once in the list to my earlier affidavit? What is the explanation given for giving him promotion?
Retrospectively from his juniors were promoted.
Exactly, exactly.
Has to be read. Taking if it is not in conflict with the cut-off date of 1st January, it has to be read in that context.
The explanation.
This is the ratio. When you read the conclusion, it has to be, if there is incongruity, the heart of the matter should be there.
True.
So heart of
But your lordships court and the Supreme Court's consistent view is that if there are two interpretations.
This is for contempt. Yes,
I'm coming to that. Secondly, what is if we
but
take.
Why I do not know why you have preferred, you mean the government has preferred an SLP against this order. And then again, this person is being deprived. All that you are required to give him a.
No, SLP was, I do not know whose advice was there and why it was done.
Because you are just the record. Why?
Because actually, the basic thing occurs from the recommendation of the state government, fixation of seniority by the state government.
Then again, in spirit, it should have been accepted. Why he should be? He's already an aged person running from pillar to post. It doesn't augur well with the institution to make him run from pillar to post. Not expected from.
No, we have not asked him to run from pillar to post because the state government has done nothing.
No, that is not correct.
You have preferred the SLP. State government has not preferred any SLP.
Page 8 of my today's report.
State government has not preferred any SLP. All that you are required to do is to implement. If I am not wrong, the SLP by the department, I think so.
Yes,
would it be?
And they have followed it in case of Parveen Kumar. So they have applied. They have reviewed the.
This has to be followed.
According to
Kindly.
This has been added by the annexure 9. State government has added it. What they have done to the Parveen Kumar case. Analogical case is Parveen Kumar. So many cases.
Kindly allow me.
Why he should be unnecessarily victimized? He should not.
He has not been unnecessarily victimized. You know, the moment your lawsuit is desired,
No, if it is not.
we have issued the
But
notification.
The Supreme Court in the first stage, we have preferred if the SLB is a person who has
This
served as
perpetuate
judge
their
for so
mistake.
long.
They are taking the advantage of their own error and.
This doesn't augur well.
My lord, would it be lawsuit's pleasure to come to page 9 of the report? Page 9 of the report.
No, we have seen this.
The list.
No.
List of juniors.
Maybe we are saying that the spirit of the order is this, it has to be implemented. How he'll implement is for you to decide. This is, we have given this relief to him, he should get this relief.
There will be a judicial order to that effect. We cannot do anything. Let it clarify in contempt.
You may not be in contempt, you may have an excuse to offer or an explanation to offer, but he should not be penalized.
No, then
He should not suffer. No. His matter is from 2015. He's in 2025.
No, my lord, my matter is from 2006.
His WPCT was
No,
filed in 2015.
WPCT was
Third round of litigation.
WPCT. Main grievance of the petitioner was non-fixation of his pay, seniority, everything by the state government.
No.
And I have, Mr. Kumar, please.
Please allow him to make his submission. We have heard you.
Now, what is the explanation? Once in the list, if your lawsuits kindly come to my earlier affidavit, filed by the alleged contender 1 and 2.
No, you have given us this. Union of India has preferred the SLP.
No, Union of India has prepared a second.
Union of India is affected by this. If they are specific to recommend it, why, how they are affected?
Because the basic thing, so far as I am made aware, that his case was not recommended by the UPSC. And since your lawsuits had been pleased to dispense with the recommendation of the UPSC, then we took up the matter, issued the notification. And for abundant caution,
This is how the person who has served the institution for long is being shown the doors, and he has to roam from here to Delhi, come back at the fag end of his life. It doesn't augur well.
No, then
If you are saying this,
then let there be a judicial order.
Yes, it's by judicial order, of course.
But kindly record some judgments, my lord, that is no contempt.
No, we'll say so. I think you are there to assist us on this, because to allow this person to go from pillar to post to seek a judgment, this is the spirit of the order. The spirit of the order is quite clear. What we meant is quite clear. So should this kind of stance be taken to frustrate a claim?
No, I am not saying this stand be taken to.
Employer, my lord. Supreme Court many a time has said that model employer should not.
I am not submitting at all this. My client was under the
facilitator, not creating an impediment.
Union is going with the orders.
Order doesn't say so, please. If you are saying something, be very careful what you say. The orders does not say that it be put below the juniors.
With the leave of learner SG, I can make submissions to that effect. The order
You
is not.
have heard. You have heard enough before this order was passed.
The order will not, you will also see the page 74. The last portion
You
of
have
the
seen
order.
the reasons. You have given the reasons for the order. You have given the reasons for the order.
Difference of respect, I may say order is also confusing one. First part of the order is saying something, second part of the order is also saying something.
No, this is the final order.
Final order, can you see the last portion, page 74?
This is, he has pointed out to us.
That is,
what is the spirit?
that is the thing I
find out the ratio of a judgment.
That is the thing I was pointing out.
Find the ratio of a judgment.
That is the thing I was pointing out to my senior.
What is the ratio of the judgment?
That is the thing I may have some conversation with my senior also.
Ratio of the judgment is something different.
Had asked the state to come with the to come in regards to the para 5 regarding the compensation
what
and
is that?
restoration issue. What have they done?
Para 4 and 5.
4 and 5.
It's limited to the steps you have taken.
Yes, limited to the restoration and rehabilitation.
Yes, yes.
এটা দেবেন
না না কাগজটা দাও এটা লাগবে
ওই
না,
ওই
আমাকে।
ছোটটা।
So,
আমরা পাবো একটা
Then,
দেন না
the investigation, no, it is the
have you paid the remuneration of the valuer?
That is in process, my lord. I had a talk with the DM today also.
Will attach your bank account.
I'm sorry, my
Not
lord.
your. Attach the bank account.
No, my lord. It will be done in course of, if not today, by tomorrow it will be done. But they are at it. They are at it. কি বাঁধে বাঁধতেও জানে না এরা এর কাজ আমাকে করতে। হেইফার মানে কি হেইফার? হেইফার মানে কি?
ever মানে gold.
What about the houses that were?
Yes, my lord. Your lordships will find the details, my lord.
Where, please tell us.
Yes, my lord. In the first page, we've given first page basically a summary. 283 families were identified for providing the reliefs. 1.2 lakh each has been given, my lord. And for that amount has also been disbursed. We have given the disbursal amount also. But page 7.
Go through it and come back after the
But is this amount adequate for rebuilding a house? Understand the nature and extent of the destruction?
Well, it was 2.45. But we have sanctioned 3.39.
We are not on the amount. You see that there may be different kind of destructions.
Absolutely.
Some may be completely gutted. Some may be one floor. Some may be one room.
But
So
no
it cannot
such
be uniform.
Yes, but
So
but
it has
Malad,
to be
this has been, your lordship can see, this has been done in May. We are almost in October. So this complaint we have not received. I'm not saying it is impossible
not
or
saying-
improbable,
You
but
see
Malad,
that,
we have not received this complaint from any sector.
No,
That has
I'm
not
on
happened.
that. We are saying this, that you have the report of the valuer. So he has assessed the compensation, correct?
Yes.
And he has more or less given the nature of the kind of destruction.
Yes.
And they also suggested that for rehabilitation, how much would be the expected expenditure.
Right.
So based on that, what is your input? That's what we wanted to know. Where is that input? Because yes, it shows that you have taken some steps,
Fine.
but that may not be fully in conformity with the report filed by the. You have the valuation report.
Yes, yes.
And he has categorized. He has visited all the localities, identified the houses, more or less, as far as possible.
Therefore,
This report must match with the report of the valuer. So that is not there. This is a broad thing that you have said that I've given this much, this much, this much.
Yes, Malad, because the disbursement was Malad, earlier than the evaluation report that came.
No, after this valuation, because these are all prior to the valuation. These are all of May.
Malad, if your lordship sees, Malad, I've given a cursory look to this Malad report, annexures. Malad, as far as the
No, Mr. Bandhavadhar.
Malad, most of the damages, Malad, just create the.
You see, even for a mud house, which is broken, you can't have with this amount. It's not possible.
Malad, the damages which has been mentioned.
You may not have to give them the amount. You reconstruct, the matter ends. Disbursement of the amount.
Most of them are below 1.2 lakhs. The assessment of damage is below
Whatever
1.2
there.
lakhs.
It could be, say, even 10,000. I'm not on that. Question is this: you identified the huts or the houses or whatever is there, shop. You take upon yourself the task of doing it. Don't give it them the money. Not
But Malad, it has already been given, Malad. 5 months have already gone by.
What I'm saying. So if anyone has not come up with any complaint, matter ends.
But they have not in 5 months.
Very
That is
well,
my
very well,
instructions.
very well.
And Malad, I was each and every Malad entry Malad, it is not possible to reconcile.
No.
But Malad, most of them are below 1.2 lakh. That is what I found. And Malad, including
Please give us a reconciled statement apropos to
the valuer
the
statement,
valuation.
valuers annexures.
And what you have disclosed are all of
May, April and May.
and the valuer has filed the report in, I think, in June or July.
Your Lordship, we do not have a copy of the report, neither do we have what he's filed today.
The
valuer's report is in court.
You can take inspection, there's no problem. Valuer report, I think.
Lordship, just one submission to make. On the last time when they said that we have already distributed this amount,
Yes.
we challenged the basis of this distribution. That how did you come to know that these are the victims? They are saying that nobody has come with a complaint. But did you open any website? Did you say anywhere that we are taking complaints for those whose houses have been destructed, that please come and let us know? You announce it tomorrow. Tomorrow they'll come and make a queue outside
This
your
is
office.
See, you are giving a figure of May. This is of July.
July, right.
So this is no update on this. This is not an updated version.
Well, this we will reconcile.
Whatever you have given here
Yes.
is a figure of April 2025.
Yes.
We are
Disbursed
not
in
in
May,
the month
disbursed
of-
in May, but before the valuer's report.
October.
But before the valuer's report.
31st
Whatever I have given before the valuer's report, you are not concerned. We are more concerned after the valuer has given the report, what steps you have taken. We are more concerned with this. This report is
But the rehabilitation and restoration had occurred before the valuer gave a report. The report of the valuer may be of July, but it relates to incidents prior in time.
no issue.
That rehabilitation had already taken place.
No issue. But if you could give us with some detail that how this fund has been
Well,
distributed.
what I'll do, well, I'll ask my client, subject to correction by your lordship, I'll ask my clients to give a reconciled report because the valuer's report has the names and our list has the names. We'll give a reconciliation that how we have done the distribution amongst whom.
And the person's name.
Person's name, because this also has the person's names, and therefore there will be a reconciled report as well.
How much amount you have disbursed so far?
3 crores 39 lakhs.
Now, that is allotment, but actual expenditure.
But actual disbursal is same.
No, but full utilization.
But utilization, since we have given to the party.
But you have given it on, see, you have released the amount in favor of the DM on 3rd
May 2025. By now, the disbursement is complete.
We should have the data.
But only one thing, my lord, on 3rd of May, they have
We should have the data. Where is that data? How you come to that conclusion that whether it is done properly? And when she is saying, Mr. Ibrawal is saying.
Well, it has been done, Malad, but I'll give the details. I've taken
this matter
page 2, last line.
No, we adjourn this matter because of that, so that we have some details and particulars with us.
Malad, the details, Malad, if your lordship sees page 3 onwards, the details and the basis is already there. That list, yes, the list of beneficiaries I'll give, Malad.
only one thing, my
But
lord,
Malad, page 2 last line indicates that it has been utilized.
in my lord's order dated 15th of May 2025. Now, in the in the 5th paragraph, it was specifically recorded that the government has formulated a rehabilitation project and a sum of rupees 3 crore 69 lakh 60,000 has been sanctioned for the purpose of rehabilitating almost 283 families who have been identified till date. Now, for providing relief for reconstruction of their dwelling houses under such and such scheme with a proposal for providing them 1.2 lakhs per household under the state development fund. So, Manoj, what, as I understand, Manoj, since a copy of the report has not been supplied to us, Manoj, it's a verbatim, possibly, Manoj, it's a reproduction of what was submitted before your lordship on that fateful day, Manoj. So, the state, what they submitted on the 15th of May,
yes,
is once again reiterating that stand, possibly.
That towards maybe the valuer has made the valuation in July, but they have in the meantime disbursed this amount.
Yes.
So we wanted to know that disbursement, if it is there, match it with the valuation report and find out that whether all of them have been given the benefits, how much is surplus or deficit, and what is more to be done. That's the only thing.
May I humbly pray for a copy of the report that they are.
It's a one page. You can give it. It's one same thing. What you read out is the same thing. Straight down.
Was
Says this, what Ms. Tibrawal has said, possibly is for bringing transparency. You can have a website where anyone having a complaint can make it directly to the office of the DM.
Well, we can do that, but Malad, I'll also indicate, Malad, we had on record 119 cases, Malad, more or less all dealing with destruction of properties. Therefore, those are on record that this property has been.
No. You see that so that there may not be any doubts raised at any time. If you have a website where there is a portal where one can enter the complaint, and whoever has been covered is covered. Others could be genuine.
May I suggest this, Malad? I'm not avoiding the question which is falling from your lordship's, Malad. But Malad, may I suggest this, Malad? Let us come back with the reconciled report, and if we find that there is a huge gap.
In the meantime, you can have a website. In the website, you can say that anyone, if any grievance with regard to restoration of this, see, you have to find out. It may be that some may have. There may be some other incident they want to come into this umbrella.
and it can be inspected by the DM office.
Yes.
Well, since my learned friend appearing in person has claims to have visited the place Malad repeatedly, she will be in the know-how of who are the persons who, in spite of a damage of property, he has not got it. Let them give us the list.
I have a list of people.
Yes, let
I will
it be
give
forwarded to us. Malad, it will be make the process easier rather than Malad.
I'll do the needful elections.